Because this year couldn't be crazy enough, guess what? The U.S. Supreme Court is still full operation. They didn't slow down. If anything, they're getting crazier as various opinions are coming down right now. We're recording this on July 1st, but a lot of them have been coming out over the last week, and there'll probably be a bunch more coming out as the week goes on. And I'm excited to be joined today by Michael McCann, professor of law over at UNH Franklin Pierce School of Law and reporter over at Sportico, sportico.com. Thanks so much for joining me today.
Thanks, AJ. Thanks for having me. Lots going on these days.
Oh, yeah, very much so. So we've been talking about the presidency and all that craziness, but let's move over to the courts because we were talking about before we started here, there's conservative majority court, which is a big deal with the changing of things that are going to be a focus. I mean, Roe being overturned was a huge deal, but there's a lot of other things that are going to be brought up over the next few years, including this past week, that are tremendously important to how our government operates, especially in D.C. And big deal for me, personal political opinions on it, I'm excited to see handed down, but I know many other people are not so sure, and the sports industry definitely has a lot of implications with this, as you wrote about in Sportico, but they have overruled Chevron. The case is Loper Bright Enterprises v. Raimondo, but it overturned a 40-year precedent. So at a high level, what was the basis of the Chevron decision?
The basis of the Chevron decision was when a federal statute is not clear about something in terms of how it should be implemented, when an agency interprets it, including through regulations, courts under the Chevron doctrine were obligated to provide a great deal of deference to the agency. So this gave agencies a lot of authority when the law itself didn't clearly define or provide an instruction as to how to interpret it. And the critique of this is that it gave agencies, which of course are not elected in the sense that the staff are not politicians, that it gave them too much discretion and that it politicized certain features of the government in ways that the public doesn't necessarily see, that doesn't get maybe as much media coverage. The supporters of Chevron would say, well, agencies have a great deal of expertise, they should have deference. And the Supreme Court now has said they will be treated like others. Some of what they do will remain lawful, but they're not going to catch a break essentially with scrutiny.
Now, big thing for me that I've got a big question for you on this is, I mean, what role did the courts have with regards to how these agencies operated up until now? I mean, was it they didn't really have much authority at all to really step in? I mean, what's the threshold for them to actually have step in and be able to have a change happen?
Yeah, part of it depends on the agency, and part of it depends on the question at hand. Certain agencies were, as a pragmatic basis, really not given the same degree of deference as others by courts. In addition, there are certain large political and legal questions that courts wouldn't apply Chevron, at least in its entirety. So Chevron, as sort of a doctrine, hasn't been uniformly applied. And that maybe means that the impact won't be quite as substantial as the headlines suggest. But still, it's a big deal because it really reins in agencies, at least in terms of ambiguous legislation. Now, there's a fix to this to some degree. Congress could pass better laws that are more clear about what to do and not giving agencies uncertainty, because I imagine the agencies would say it's not about aggrandizing power, it's about we don't know what to do. And because Congress drafts laws in ways that maybe are deficiently vague, we have had to step in. So perhaps Congress going forward, I don't know if this will happen, but in an ideal world, they'll write better laws that provide more clarity on how agencies should follow them.
Now, state of New Hampshire, with how our government operates, the state agencies create rules, and the rules are what are followed, and it's very similar with regards to how federal agencies work. But in New Hampshire, the rules are approved by the legislature. Like, they go in front of committees for that. Do similar things happen at the federal level?
Not precisely. It really, agencies are given interpretive power. Now, there are ways in which congressional hearings can provide some greater instruction. There's always a debate about the role of legislative history in interpreting law. Some judges would say if the law doesn't actually say it, it doesn't count. Others would say, and some judges would say, I mean, Justice Scalia, the late Justice Scalia, was very skeptical of using legislative history because if it's not in the law, that may itself be indicative that we shouldn't follow the history. Now, others would say, wait a second, you have all these hearings, a lot of information is conveyed. So there's debates about how to handle that. I think what we've seen is that the administrative state on a federal level is pretty robust. And it sometimes acts in ways that are politically driven. Other times, it seems that it's more as a technocrat, right, trying to do what's right in terms of what the law says. It really varies. And it's also interesting because Chevron, the defeat of Chevron, I think, is seen by conservatives as a good thing. Now, that may be true, but keep in mind, the agencies are largely swayed by who's president. So if the next president is President Trump, the agencies will be more conservative, and what they do could face greater scrutiny in the courts. So it's like the pendulum, right? As one administration is a Democrat, one is a Republican. I mean, what this really does is it sort of empowers courts and directs Congress to be maybe more directive in terms of legislative drafting.
Like from a legislative check and balance, I personally think it's awesome because if you're not happy with how these administrative agencies are operating and they have more oversight over what's going in, what Congress has more oversight over what they're doing, I mean, hey, actually start getting some new blood over in Congress could actually have some effect, in my opinion. But it'll be interesting to see how that honestly plays out because it depends on how much in the weeds a lot of these agencies end up having issues. I mean, it's interesting here, this Loper Bright case, this administrative agency had direct impact on this business and their ability to operate. They're charging them $700 a day for a person. They had to pay for this person to be on their boat every day. Can you talk a little bit about the case at hand that kind of led to this?
Yeah, there's a sports hook of sorts. It's a fishing, right? So fisheries were subject to a National Marine Fisheries Service regulation that, as you noted, AJ, required boats to allow a person on board to collect conservation data, and they have to pay that person about $710 a day, which for this fishery was apparently about 20% of its revenue. So that's obviously a pretty sizable cost. And the fishery said, well, where in the law does it talk about this? And the law doesn't at least directly talk about it, but in the laws, the Magnuson-Stevens Fishery Conservation and Management Act, it sort of implies there could be a fine or a penalty scheme if one doesn't do this. And that was enough for the agency, the National Marine Fisheries Service, to adopt this. So the question becomes, okay, the actual law doesn't talk about this. Can the agency interpret what the law says and adopt this? And the lower courts had said yes, because under Chevron, the agency is given a lot of deference. Here, the Supreme Court, Chief Justice Roberts wrote the opinion, said, wait a second, no, that we shouldn't say the agency is presumptively correct when there's ambiguity. We should review it as we do anything else. We should look at it and scrutinize it. Doesn't mean it's illegal, doesn't mean it's legal, but let's not give deference to the agency. And Chief Justice Roberts said, if anything, courts should be more scrutinizing of agencies because maybe they have an incentive to come up with a scheme to raise money. I mean, a penalty scheme to raise money. So, it's an interesting case. The counter argument is that this will lead to diminishing power of agencies, that it will lead maybe to more litigation, maybe more challenges. I don't know if that's going to happen. But that's sort of the thrust of the case.
And it seems like a lot of people online don't understand the fact these agencies go to court a fair bit. At least I see it's I mean, this is something they do. It's just it's being taken more to the rules level as opposed to whether people are forcing people to follow the rules that are required upon them or extreme circumstances. Like these agencies are lawyered up. They're prepared to go to court if they got to go to court, and they will adjust their staffing accordingly too. Like these agencies are not these poor group of people that have no way to defend themselves at all.
No, and it's tough for a lot of folks to challenge agencies, right? It's expensive, and most people can't afford to just sort of take. I mean, this is true generally. This is one of the hurdles of the legal system, is that if you don't have resources, it can be tough to mount a challenge. I mean, there are ways of mitigating that, but still. And here, as you mentioned, federal agencies have a great deal of authority. They have staff, they have financial resources to essentially make their case in court without having the same kind of budget that you or I would have in challenging them. So in a way, you might say this levels the playing field a bit. Perhaps that's certainly one of the arguments in favor of this type of decision.
One of the arguments against this ruling has been this is going to put too much importance on the court, and it's a judicial cash grab essentially for the courts to be able to have free reign over the executive branch. I mean, is that something that some of the dissent mentioned?
Yeah, that's certainly in the dissent, that this is essentially aggrandizing the power of the judiciary. I think that the pushback to that is that it's not saying the agency can't win. It's saying the agency doesn't get the same degree of deference. And let's see, in fact, if the agency loses. The agency still has a lot of advantages, right? There are experts. They have the power of the agency. There's something to be said about an agency, right? It's authoritative that, maybe a fishing company isn't going to have, especially a small one. So whether this actually radically changes decisions, I'm not sure. And as we talked about earlier, the Chevron standard hasn't always been applied. It really depends on the issue. To some degree, it depends on the agency. So the impact of this may not be as pronounced as some who are worried about it may believe.
So let's go specifically to one of your, I don't want to say pet story, but I'm going to say pet story, name, image, likeness, which is something that's been all over the state level governments, but it's definitely also been over in Washington, D.C. with Congress and the NLRB and things like that. I mean, what's your predictions on a ruling like this having an impact on the future of name, image, likeness, expansion, or pullback?
Yeah, so this certainly, name, image, likeness, the rights of college athletes to do, and I would say NIL really is about removing a restraint on a right athletes already had, right? We all have the right of publicity. Name, image, and likeness through Ed O'Bannon, it was about removing a restraint on a right that college athletes already had as Americans, but was curtailed by the NCAA. The relevance here of Chevron is that it's possible that the Federal Trade Commission will, for instance, regulate college sports agents. That's something that's been talked about. Or a federal NIL bill. None of them have actually advanced out of committee in Congress, but to the extent something like that happens, the agency, presumably the FTC, would oversee it. How they handle that would now be subject to greater or less deferential scrutiny, I would put it that way. And of course, the FTC wants to ban non-competes. That's something that has been pursued. It's already been challenged in court, but the removal of the Chevron doctrine likely will make those challenges, at least subsequent challenges, more effective. There are other ways in which the removal of Chevron could impact sports. If we look at sports broadcasting, the regulation of sports broadcasting, there's all sorts of possibilities. The SEC, even in terms of regulating the crypto market. There are lots of ways in which, and of course, the big one, are college athletes' employees. That's something where the federal law is actually pretty ambiguous about that. And we know that there are conflicting takes on that. So, removal of Chevron, it's going to affect sports. It's going to affect all sorts of industries. But I think it remains to be seen exactly how impactful it proves to be.
It's just like Roe, where this is opening the can of worms to see what'll happen. Like this is we're not waking up last Saturday and oh my God, the EPA has no more authority over anything at all, and they're being thrown out the window. There's a lot of sky is falling mentality online around this case, which is understandable. If you're someone that's a huge supporter of what some administrative agencies are doing, and you suddenly think, oh, they have no more authority to do anything. Yeah, that's terrifying, of course, but we're not there yet, and things are going to work out over time.
We're not there yet, and agencies have exactly the same authority before this decision and after it. The difference is their decisions are not subject to the same deference that they got before. That's really the change. That if they're right about what they're doing, they should still win every case. And at the end of the day, that and I think as we talked about, agencies have big budgets. Agencies have experts. It's not as if they're suddenly going to be, looking up from the bottom, trying to climb their way up. These are powerful entities that presumably that maintain all of those advantages. What they lose is the deference. So I don't know if we're going to suddenly see agency. I don't think we're going to see agencies curtailed in how they act. I think maybe they will need to hone their arguments a little bit better. And I think the role of Congress. Will Congress try to mitigate concerns that have been raised about laws that are not necessarily drafted too well? Maybe they'll draft better laws. We'll have to see.
It kind of brings it in. What's been in the back of my head this whole time, too, is it kind of brings the executive regulatory agencies in line with the Constitution, with the checks and balances that every other branch of the government already has to follow. And these regulatory agencies are kind of this weird gray area under the executive. They're under the executive branch, but they kind of have this weird operating authority that's separate from it. And it's like now they're going to have the same checks and balances that the president already has for executive orders and things like that.
Yeah, this is really about removing deference and holding agencies accountable. Now, will that mean that there will be more litigation and that businesses that have a lot of money might now have more running room to bring cases? Possibly. I don't think it's the end of the EPA. I don't think it's the end of any of these agencies. I think we'll still see agencies powerful. And if this means that they have to make better arguments, that's not necessarily a bad thing.
Michael McCann, professor of law at UNH Franklin Pierce School of Law, law.unh.edu to learn more about them, and a writer for Sportico, sportico.com. A link in the episode description, his article on this, as well as the SCOTUS blog article that is strictly on the striking down of Chevron. Thank you so much for joining me today, Mike.
Thanks, AJ. Appreciate it.
NewEnglandTake.com to get more from the show. Please like and subscribe. If you are on YouTube, I'm going to start posting the podcast feeds again, so please be sure to check that out, and we'll talk to you soon.